Defense Exhibit FV. If I may approach the witness.
You may.
Do you recognize that map, sir? I can,
If it's attached to an email, is that correct?
yes, it is. May I show the witness Defense Exhibit FU?
Yes.
Yes, sir.
Is that an email that you sent on November 15th, 2008?
That would be correct.
Okay, and taking a look at that map, does it fairly and accurately depict the locations where you searched?
Well, okay.
I think you can answer.
You can ask.
It would be a fair and accurate representation, although it would not be specifically. Yes, sir, there are.
Okay, and does it show the location where you searched? The pin?
Where I looked in?
That's a Google map, is it not?
Yes, sir, it is. I pulled up a Google.
Okay. And then you did a pinpoints?
No, actually, I'll tell you what happened. To the best of my recollection, Luke sent me an email with this and said where I looked onto Suburban Drive.
Okay. But before we go any further, Judge, I'd like to admit into evidence. Defense FB.
What says the state?
I'm just citing the state's previous objection.
Objection overruled. Be received in evidence as defense exhibit.
Number 73.
This map was prepared in November of 2008, correct?
Yes, sir.
Either the same day or right around the day that you actually searched this area?
That's, I believe the email.
Not identify himself as creating the map.
He did. He said he put the pinpoints on there. He sent the map and then he put the pins of where he searched.
Overruled at this point. Go ahead, sir.
Now, sir, my point is, where you had searched was much fresher in your mind on November 15th, 2008 than it is now 3 years later, correct?
Oh, definitely so, yes.
Oh. My question to you, when did you go out to Suburban Drive to search? Do you know the exact dates?
Yes, sir.
What dates?
November the 15th, 2008.
And the 16th?
November the 16th, correct.
Okay. So this was emailed the day that you actually searched there?
It was sent to me via email that night after Luke called me and said Jeanette wants to know.
Sustained.
Just listen to the question, sir, and just answer the.
Okay.
November 15th, you searched. Is that a yes?
November the 15th, I went to the location and walked around. That is correct.
Okay. And November 15th at 7:51 p.m., you sent this email.
Yes, sir.
Okay. This email and verify that the pins are at the same locations, if you can.
Okay. Yeah, I'd say they're within the right. Yeah. This will be inaccurate, though.
What would be accurate?
Let's see it because it was closer to the bend.
Okay, but is this? Is this map a blown up map of this? Does it appear to be the same map?
It appears to be a blown-up version, and when I see the blown-up version, the pin mark should be closer to the, it was more at the bend.
Okay.
So is that what it's showing? If that's what it's showing there, then that would be true.
Now, sir. Everything you've testified in this case so far, obviously, is further in time than November 15th, correct?
Yes, sir.
May I publish this to the jury, Your Honor?
That's some evidence?
Yes.
You may.
Is the location off Suburban Drive, correct?
The one on the south
One
side?
on the left, and then abandoned house.
Yes, sir.
Okay. I have no further questions.
Cross-examination?
Thank you, Judge. Okay. Good morning, Mr. Casey.
Good morning, Mr. George. How are you?
I'm fine, sir. Thank you. When you dropped or marked this map, Defense 73, with a pin, you weren't being precise, correct?
No, I wouldn't say it's an exact representation of where it was the best guesstimate.
It's a very general area of where you searched, correct?
Where I went, correct.
Where you went.
Yes, sir.
All right. And defense also showed you the blow-up of Defense 57. And you had indicated that, make sure I have this correct, where you searched on Suburban Drive was closer to the bend in the road, correct?
I used the bend in the road as the reference point.
Sure. And that-
So,
I'm sorry, I didn't mean to interrupt you.
no, I apologize. And on the smaller, the 8.5 by 11, you can't, the 8.5 by 11 inches paper. When you look at that and then you look at the larger one, it brings it more into a perspective.
I'm sorry.
No, I apologize.
You're done.
Now, as far as that pin goes, okay, I do recall that from the bend, okay, if you headed west, which would be toward you, okay, I probably came in, be plus or minus, and then took a right turn because it was open. That was the open area that you could walk. And I probably walked maybe 20, 30, 40 feet. So I would have been walking towards that green pin.
But the general point is that these pins aren't indicative of exactly where you went, correct?
No, sir.
Is that correct?
That is correct.
You were able to tell us, thank you, you were able to tell us where you exactly were, correct? Or the best guess
To the
at
best
that
of my
point?
knowledge, 3 years later, yes.
All right, so this map doesn't really help you all that much, does it?
Well, it is one that I put the pins in.
Right, but as you just indicated, this is a very general idea of where you went into the woods, correct?
Yes, as that would be.
Okay.
Yeah.
Thank you. Thank you, Mr. Casey. Thank you, Judge. I have nothing else.
Thank you.
Any,
This is something you prepared 3 years ago,
Yes, sir, that would be true.
the day you searched out there.
Absolutely.
Would you agree that Orlando is 101 square miles? And this is the only place where you searched for a deceased Caylee in the entire 101 square miles of Orlando?
That would be the only place that I went to, that one on the south side and that one on the north side.
So
That
the
would be
answer is
correct.
yes, right?
Yes.
No further questions.
may the witness be excused? Yes, sir. Thank you, Mr. Casey. You may be excused, sir.
Thanks, sir, very much.
Relates to defense FS?
You offering that in evidence?
Yes, sir.
Any objections from the state of Florida?
No, Your Honor, I believe the stipulation bears my signature.
hand it to the clerk so she can remark it and be received in evidence as defense exhibit.
Number 74.
Ladies and gentlemen of the jury, the following is a stipulation between the state of Florida and the defendant. The attached video is a true and accurate copy of a news video taken during the first week of August 2008 depicting the command center manned by George Anthony located at 4466 North John Young Parkway, Orlando, Florida 32804. The parties have agreed to this fact, and it should be considered as true in your deliberations, bearing the signature of Mr. Jose Baez and the defendant, and the replica and symbol for the signature of Ms. Linda Drain Burdick.
I think we have her original signature.
That's the copy, that's not the original.
Oh, well, I'm just reading what was given to me. All right, this one here bears her actual signature. You may publish.
Feed was cut. All right, double check.
You're publishing it now?
He's about to, yes.
Well, you need to put it so it'll go on the screen.
Oh, hold on. Okay. Pause it. That concludes the video, Your Honor.
Thank you. You may.
Your Honor, the defense calls George Anthony.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
George Anthony, George
Video that was presented.
Yes, sir, I did.
And did you see the duct tape that was there?
Yes, sir.
That was your duct tape.
Could have been someone else's. I have no idea, sir.
That could have been somebody else's duct tape?
Yes, sir.
Ask and answer.
Sustain.
Did anyone during the time at the command center bring duct tape to the command center?
Which command center, which location, sir, are you talking about?
The location that was shown in the video.
Which location is that, sir?
I can have a moment. Sir, you didn't recognize that location in the video as being close to your home.
Sir, I'm asking the location, sir. We had numerous command centers that moved around.
4466 North John Young Parkway in Orlando.
No, sir. We never had video you're talking about. I have no idea where that was taken at, sir, but it wasn't on John Young Parkway.
Okay. So was that a Publix where you were at in that video?
Yes, sir. That was a Publix.
Okay. Do you know which Publix that was?
That particular one, no, sir. We had different locations we went to.
How many different publics did you go to, sir?
At least 2 that I can remember.
Okay, so there's 2. There's not 50.
I just answered you 2. Saw that we had by Curry Ford Road.
Do you know which one of those 2 that video was taken at?
Not at this time, no, sir, I don't.
And at that location, at that time, in the first week of August 2008, where was your command center?
We had one at the corner of Lake Underhill and Chickasaw, North Chickasaw.
Okay. At that location, did anybody else bring Henkel brand duct tape to your command center?
I have no idea, sir.
You have no idea.
I have no idea.
And you have no idea if that's your duct tape.
I have no idea, sir. I just answered that.
Okay. Sir, I'd like to ask you if when you came from Ohio, right?
Yes.
That's the same place Henkel brand duct tape is made.
I have no idea where it was made at, sir.
Okay. And when you lived in Ohio, sir, did you have a dog named Mandy?
Objection to relevance of having a dog in Ohio.
I will be tying it in.
I would like to approach
Approach.
have relevance to that.
Objection overruled.
Did you have a dog named Mandy in Ohio, sir?
Yes.
Okay. Did there come a time where the dog had to be either put down or was it?
In our yard where we used to live at,
Did you pick the dog up at the vet?
yes.
And was the dog wrapped in a blanket?
To the best of my recollection, probably, yes.
Was the dog then placed in
Our home and placed there. Yes.
was it also wrapped in duct tape?
Sir, I have no idea. You're going back almost 30 years here, sir. 25 to 30 years.
And was that before Casey was born?
Yes.
When you moved here, did you have a dog named Bo?
Yes.
And how was Bo buried?
I can't remember the exact year, sir.
Okay. Was it 15 years ago, 10 years ago?
Could have been 15 or more years ago.
Okay. How old was Casey at that time?
Somewhere in the neighborhood, probably about 4 or 5 years old. I'm just roughly guessing here.
Okay. And was Bo buried in a blanket, in a plastic bag, wrapped with duct tape?
He was in distress. He was dying.
Did you have a cat named Penny?
Yes.
Was Penny buried in a plastic bag with duct tape wrapped around?
No.
What about Ginger?
No.
Is that a dog or a cat?
That's a dog.
Okay. Was Ginger wrapped in a bag with duct tape wrapped around it?
I don't remember exactly how our animals were finally put to rest. I can't answer that exactly precisely to you.
What about Cinnamon?
Again, that'll be the same answer.
Okay. And Misty?
Never had a dog, Misty.
Okay. When you found out that your granddaughter was found and with a blanket and with a plastic bag and with duct tape, did you tell law enforcement at any time over the last 3 years that that is the way you used to bury your pets?
Objection, improper impeachment, may approach.
Yeah.
I have no further questions. So,
Objection sustained. You have no more questions. Thank you. Mr. Ashton?
Mr. Anthony, have you ever taken a dead pet and thrown him in a swamp?
No, sir.
No further
Overruled.
questions.
May the witness be excused. Thank you, Mr. Anthony. You may be excused, sir.
Thank you, sir.
Cynthia Anthony, Cynthia Anthony.
You may proceed.
Thank you, Your Honor. Good morning, Ms. And that was 20-plus years ago?
I got her in 1981.
Okay. Would that have been before, when she passed, was Casey alive?
Yes,
Okay. A baby?
yes, she was a toddler.
Okay. And did there come a time where you took Mandy to the vet because she was either dying or had to be put down
Yes, I took her.
and buried?
Yes, I made an appointment to take her. She had been very ill, and I knew she was going to be placed down because that was a conversation before I took her to the vet. And they told me to bring something that I might want to put her with, like a stuffed animal or a blanket or whatever. So I brought a blanket that we actually had. She was my first baby, actually, before I had the kids. And so you know how pets become your babies. And I had bought a baby blanket for her. So that blanket I took with her to the vet, and I was holding Mandy when they gave her the injection. And then they took her from me and the blanket. And I don't know how they put her, but I received her back. She was already wrapped in black plastic with like packing tape.
Did you have a dog named Bo?
Yes,
And that was when you moved here to Florida?
yes.
And when did Bo pass away?
The summer of 1990.
Okay. And how was Bo buried?
We buried him in the backyard. Vet, and I was at work. Georgia and Casey took Bo to the vet when he was in distress. And the vet, he actually died on the table while the vet was looking at him. And the vet secured him. And then later that evening when I got home from work, he was already ready to be buried. So George and I and the kids had a little ceremony in the back. It was our first summer there, so I think she had just had her 4th birthday.
And was the bed buried in a plastic bag with tape wrapped around?
I believe it was in black plastic. I'm not sure if it was a bag, but it was black plastic and again with tape.
And did you have any other pets that were buried that way?
Well, there was no other pets.
Those.
Pretty much the same way. If we didn't have a blanket or something, we had like a towel or something that we would use, like if we gave them a bath or whatever, a special towel that we had set aside for them. Ginger, Cinnamon were buried with a towel, and then I think we may have put a favorite toy with one of the Cocker Spaniels, and then we put them in a couple layers of plastic garbage bags and then wrapped them with clear packing tape.
Okay. Did you ever tell me that they were wrapped in duct tape?
Your Honor, objection.
I'll withdraw the question.
Sustained.
I'll withdraw the question. Are there any other, would that be the rest of the pets that you had were all buried the same way?
Penny, my cat, in 2009, he passed, and I put him in actually one of Caylee's hooded bath towels. It was very special to me, and I placed him in that and then put him in the plastic bags and then wrapped him with packing tape.
No further questions.
Cinnamon and Ginger were 2 Cocker Spaniels,
Yes, ma'am.
mom and baby,
Yes, ma'am.
and they passed away within 6 months of each other, correct?
Approximately.
Okay, the first in the fall of 2003, is that accurate?
I think so.
and the other either in the winter or spring of 2004.
Yes, ma'am.
Your daughter Casey would have been a senior in high school at that time, correct?
Yes.
And Casey assisted you in wrapping either cinnamon or ginger or both, correct?
I believe she was present. I think it was George and I that actually wrapped the dogs.
Well, the reason for putting the tape around the bag was so that the bag would be compact for burial, correct?
Yes.
And you said this was a family tradition, correct?
Pretty much to have them, I mean, we started out, I buried Mandy in our backyard. And when we moved to Florida, we designated a spot at our home that, you know, if any of the animals passed, we would put them there, if possible.
But this is something that your family did for a period of years that your children were aware of, correct?
Yes, and we even had a dog, not really a headstone, but George had found a dog made of stone that we kind of marked the spots.
A little memorial marker in the
Yes.
yard for
Yes,
the dog.
ma'am.
All right. And was Casey present when the dogs were buried?
I'm not sure if she was present for cinnamon and ginger, both of them, but I believe she was present at one of them. And I know she was present with Bo. She was not present with Mandy.
Okay.
And
That
not
was
with Penny.
2009. Or that was the late 80s.
Yeah, that was in the 80s, because she was little. I had her with neighbors. George was working, and I came home and buried her by myself because I didn't want the kids.
Right.
They didn't even know she was put down. I wanted to wait and tell them.
All right. But definitely by the time she's a senior in high school, she was aware of the burial and the method of burial in the yard.
Yes, ma'am.
That's all I have, Your Honor.
Redirect.
The tape was used to secure the top of the bag so it wouldn't open.
The tape was placed around the bags in two locations, the top and the bottom, so that when we rolled it, to keep the air out, so that, you know, we were trying to keep things from getting into the bag. So we placed tape like at thirds, like 1/3 and 2/3.
No further questions.
May the witness be excused.
Yes.
Thank you, ma'am. You may
Thank
be
you.
excused.
Lee Anthony, Leeanthony.
You may proceed.
Thank you, Your Honor. Good morning, Mr. Anthony.
Morning.
Were you present, how old were you when Mandy passed away in Ohio?
Very young, 3.
When was the first time that you remember your family having to bury a pet?
I don't remember being present for Bo. I remember that we had to bury him, but I don't remember being present for him. Same goes for Ginger. I wasn't here, but I was here when
Was she in a plastic bag with duct tape?
she was in a black plastic bag, and I do recall there being duct tape used to secure the bag.
Okay. Duct tape wasn't used. Oh, I'll withdraw that. Were there any other pets that you were present for the burial?
Similar circumstances, but that was given to us by the vet. No other family pet that I can recall being present for the burial, or if I was too young to remember.
And how was that pet given to you from your grandmother?
My grandmother's, it was also in a black plastic, like garbage bag. It was taped. I believe it was more of a clear tape. And it was very cold. She was kind of on ice until we picked her up.
Who is in charge of burying your family pets?
Typically would have been my parents.
Okay. I have no further questions.
Cross-examination? None. May the witness be excused. Thank you, sir. You may be excused. Now, Assistant State Attorney, both sides ready to proceed.
Well, actually, we do have to.
Your Honor, before we broke, there was reference to state producing to us this morning a stack of records related to employment records of Miss Cindy Anthony, do you call that? And we, of course, objected, and there needs to be a Richardson inquiry about that, so.
Well, let's finish with your end, and then we can take up their end if they have rebuttal.
Can we approach briefly without the court reporter or just one?
Yeah. Okay, Mr. Baez, do you intend to present any more live witnesses?
No, sir, we do not.
Will the defendant be testifying?
No, sir.
Okay. I have some questions I need to ask of your client.
Yes, sir.
Ms. Anthony, do you understand, first of all, is it your decision not to testify based upon consultation with your counsel?
Yes, sir.
You understand that your decision to testify or not testify is solely your decision and your decision alone?
Yes, sir.
And it is your decision not to testify?
Yes, sir.
Have you had ample time to discuss this matter with your attorneys, that is, the pros and cons of testifying or not testifying?
Yes, sir.
And has anyone used any force or pressure in making you arrive at that decision?
No, sir.
And that decision is your decision freely and voluntarily?
Yes, sir.
Okay, thank you, ma'am. All right, let's return to jury. Mr. Baez, you may proceed, sir.
Your Honor, we'd like a stipulation that we have read into the record
Okay.
and introducing the accompanying documents.
Stipulation between the state of Florida and the defendant. The attached documents are true and accurate records of the business records for Surtec brands. The parties have agreed to this fact, and it should be considered as true in your deliberations, bearing the signatures of Linda Drain Burdick, Jose Baez, and Ms. Caylee Marie Anthony. Is this stipulation true and correct, Ms. Burdick? And as a result,
Sure tape, the Henkel brand duct tape.
and that is currently marked as identification numbered what, Madam Clerk?
FW.
And the defense offering that in the evidence, there being no objections from the state of Florida, it will be received in evidence as defense exhibit numbered.
Number 75.
Okay, Mr. Baez, you may call your next witness.
Your Honor, the defense rests.
Ladies and gentlemen of the jury, there are going to be some matters we're going to need to take up outside of your presence. It should not take too long, but I'm not going to run a guesstimate on how long it would take So we will get back with you as quickly as possible. Please do not discuss this case among yourselves nor with anyone else. And please remember all of my previous admonition. Let's excuse the jury. Does the state intend to present rebuttal testimony?
We do, Your Honor, and the estimated time for that is less than a day.
Okay, there is a issue that the defense has raised and with some discovery. Mr. Baez, would you present your concerns about this issue?
Your Honor, yesterday afternoon, the counsel advised us that they were expecting some records, some documents to be coming in from somewhere regarding the employment/work records of Cindy Anthony, and for the obvious purpose of attempting to impeach her testimony as to whether she was at work or not at work on the time that she testified that she had made herself the computer inquiries regarding chloroform. And they then this morning did present us with a few hundred pages of records of some kind regarding various people. And we're objecting to this testimony on the basis of a clear discovery violation. Miss Anthony's testimony was not new or a surprise. In fact, she had testified in deposition regarding various things, including this issue back of 2009, almost 2 years ago. They knew since then that Mrs. Anthony, Cindy Anthony, had disclosed that it was she believed had made those computer searches, and yet having that consistent with her prior testimony, and then subpoena records for the first time to come in and show us now. That is a discovery violation. It is prejudice to the defense because we have already, relying on the case history and the sworn testimony, called Miss Anthony to testify regarding her search and her records and so forth. And in fact, counsel for the prosecution cross-examined her on that issue and then goes out apparently and obtains witnesses from this company and bring in business records or whatever to now impeach that testimony. So we are indeed prejudiced by that discovery violation, and as a result of that, move the court to impose the appropriate sanction, which is to prohibit that part of the rebuttal testimony.
Okay, response from the state of Florida.
Your Honor, for the court's information, the documents that we intend to present are as follows. There is a one page to start with. There is a one-page document that is entitled Report for CMANTHON, which is the username. It's a login and logout report of a Unity site, Gentiva, the employer of Ms. Anthony, for the week that begins March 17th. In addition, there is a series that begins with deleted emails of Ms. Anthony's, purporting to be Ms. Anthony's, for the week beginning the 17th and ending the 21st. Cindy Anthony.
Okay.
We have only asked for documents that are labeled deleted emails, sent emails, and received emails for the dates in question. The largest document is a multi-page document. The reason it looks as big as it does is because it's an Excel spreadsheet that doesn't quite print format, so it's broken up into two separate sections. But I will tell the court the broken up version is 232 pages, so half of that is about the length of the document. This is purported to be the workspace or desktop login and activity of Cindy Anthony. It has the job entries, the job dates, the job time, terminal at Gentiva that was used to produce these records, the username, and then additional information regarding patient activity, with the patient information removed because of the potential HIPAA implications of identifying those individuals. It is correct for Mr. Mason to say that Ms. Anthony talked about doing chlorophyll searches at her deposition in July of 2009. At that time, Mrs. Anthony did not extensively dispute the accuracy of her work records. In fact, during her testimony, she talked extensively here in court last week, and I believe that was last Thursday, about the fact that Gentiva would have these documents, that she didn't have access to them. She talked about passwords and computer activity during her testimony last week that she, as has been discussed throughout this case because of various hearings regarding discovery violations, knows that the sanction of exclusion is the ultimate sanction. I would note that the information was first requested from Gentiva through the Orange County Sheriff's Office, upon which would have been last Friday. They caused to have an investigative subpoena issued for any documents that could either support or refute Mrs. Anthony's claims. These documents, since they are separate types of records, came in pieces beginning the 27th of June, which would have been Monday, the 28th, and the 29th. They were brought to me yesterday afternoon. I told them I would review them last night and provide a copy today, which I did. Mr. Camperlengo, that's Camperlengo, John Camperlengo, is the Chief Compliance Officer for Gentiva. He came here from Atlanta and is prepared to testify as the Compliance Officer and Custodian of Records as to the actor, and indicates that she needs some additional time to speak with him. That should cure any prejudice, if any, to counsel for the late receipt of these documents that was necessitated by Ms. Anthony's testimony last week.
Mr. Mason?
Your Honor, you have quite a number of times admonished all counsel that this is not to be a trial by ambush. Ms. Anthony gave the testimony 2 years ago. The state of Florida, with all its resources and its continuing investigation, explored everything. We took, after I joined this case last year, over 150 depositions. 27,000 plus pages of documents bait stamped by the state attorney's office have been provided to us. At no time in Ms. Anthony's deposition or inquiry was there ever an issue raised about the work records they're now seeking to introduce. She clearly testified about the issue of the chloroform and the search. We have, of course, the transcript of that from 2 years ago. The state should not be allowed to sit back and let Ms. Anthony testify on such an important issue and then spring on us in the 8th week of these proceedings witnesses to claim that she testified falsely. That is a discovery violation, I submit to Your Honor, that can only be met with saying, no, you don't get to do that. They suspected that she was not telling you. You must not reward the prosecution and support the prejudice in a capital murder case such as this. We urge you to realize this as a fact is a discovery violation. It is material. We are prejudiced by the activities. It's just not adequate to get rid of that. I urge you to accept my or tennis motion now made to prohibit those witnesses from testifying or introducing any of those documents and records because of the clear discovery violation under 3.220 of the Florida Rules of Criminal Procedure and your specific and repeated orders and admonishments.
I have a question that I want both sides to address at the appropriate time. When Mrs. Anthony's deposition was given, did she give an indication, contest the validity of her employment records, which showed the various times that she was working?
I, with the court's permission, would defer to who was there at the time. That would be Mr. Biden.
And whether or not she ever searched for chloroform, how to make chloroform, things along those lines.
And what were her answers at that time during her deposition?
She did indicate that she made searches for chlorophyll, and the reason for that was because her dogs were, she suspected, chewing on bamboo leaves because they were acting lethargic over the course of Monday, Tuesday, and Wednesday.
And when did you notify the defense that you had those records and provided them copies of the records?
I notified them yesterday that I was expecting records from Gentiva. I may have indicated earlier this week that we were looking into having a custodian of records from Gentiva come to testify, but that I had not yet received any documents and that I would let them know when they actually arrived. And yesterday in court, they were brought to me.
Is this an issue that the state of Florida knew about back when you took the deposition, or is this a new issue that has arisen since Ms. Anthony testified?
I can say that I knew that she would testify to conducting chlorophyll searches. I did not anticipate that she would dispute the accuracy of her work records so extensively. She may have, and I haven't looked for it, she may have mentioned that she is a salaried employee and can come and go as she pleases during her deposition, but there was no further dispute to the extent that she testified to it last Thursday during cross-examination.
I would add that she did, in fact, say she searched chloroform, or she may have searched chloroform. And in just looking at page 152, I see where she writes, as to her answer, and possibly chloroform because my animals, because my cocker and my Yorkies would eat a lot of bamboo leaves, and I know there's chlorophyll in those leaves, and they were getting sick, quite sick. And she also says a little further up on the page, on line 9 through 12, that she remembers looking up chlorophyll back in March, which are the key times of last year, and I'm not sure if I looked up chloroform as well. I looked up alcohol and several other things like that, like ethanol, alcohol, and peroxide too. And these searches, the alcohol and peroxide, they're also in the March timeframe. So,
was there any awareness on part of the defense that Mrs. Anthony would testify that even though her work record showed that she was at work, that she would come in and say that those records are not accurate, and that it doesn't necessarily reflect that she was at work?
I think what we had here is we had the witness testifying to these searches in the March timeframe, which is specifically these items are what is in question. So to answer your question, she did say, as Ms. Drain-Burdick said, she was a salaried employee. Salaried employees come and go. So I think that we both expected her to testify that she did these searches.
I'm not talking about the searches. The question I asked was whether or not the defense was aware that she would come in and say this is accurate and in fact meaningless.
Yes, I think both sides were aware of that and expected her to testify to that. So yes.
And did she ever say that in her deposition or any sworn statement?
I believe Ms. Drain, when she stated that that was an area that she touched upon, it was, I would agree with her on that. How far she went into it, I do not know. It was Ms. Drain-Burdick's deposition. So that is, the answer is a kind of yes.
Okay. Other than the possibility of her testimony being impeached, what prejudice, if any, would the defense suffer if those records were brought in to contradict, that in fact contradicts her testimony?
I think it would, and that certainly is not something that the defense intended on doing. We took Mrs. Anthony's representations that she's a salaried employee and does not punch a clock, and that she ran these searches, and in fact, it was in the March timeframe with the exact items of what was done. So I don't think there is a remedy short of exclusion. Even if we were granted the ability to call Mrs. Anthony back on sur rebuttal, what's to stop Mrs. Anthony from pleading the Fifth Amendment? Because now that opens up a whole area of other problems.
Well, she gets up here and plead the Fifth Amendment, then we'll deal with that. If we deal with that may, and I use the word may, cause testimony to be stricken.
And there's another thing, Judge.
Okay.
There's another problem. I think this is way too late. We're right at the close of our case. Okay. We've rested, and they're now giving us these documents. We certainly could have attacked this evidence in another manner, or actually not. If this is in fact misleading the jury, that's not a stigma we want attached to the defense, that we are presenting false testimony, and that is where we are significantly prejudiced.
Unfortunately, neither the defense nor the state, unless some witness before they takes the stand tells you I'm going to get up and lie, and then you put the witness on knowing that they will lie, that's when counsel gets into trouble. But unfortunately,
This is a true and accurate reflection of those types of records. This is no simple issue. This is one that is complex, that is a stack of documents that the state this morning decides to drop on us, like, okay, here you go. And I think that the timing is way too late.
well, let me ask you this. Before Miss Cynthia, fact that she was at home and not at work, as her employment records would indicate.
As the records that we had in the discovery, yes. And in fact, they were already in evidence. So yes, they are in, the work records are not something that we've disputed. And the council had the ability to verify the veracity of.
Well, let me rephrase my question. Were you aware when Ms. Anthony took the stand, she was going to testify that despite the fact that the records showed that she was at work, that those work records were meaningless?
Yes, sir. And any further testimony that Ms. Drain just finished arguing about, these were statements that she elicited during the process of cross-examination, knowing full well that that was what she intended on doing.
Okay. But you knew she was going to testify to that? Yes, sir. Okay. Now, the work records that were introduced, were those work records computer generated?
They appear to be, yes.
I didn't do discovery. I'm asking y'all. Y'all did it.
It's a time card history report, so yes.
Was it generated by the use of a computer?
Yes,
Or were they
it's not
or were they manually done?
No, it's computer generated.
Now, were there any indications on those records where someone had an expert to look at those records to see if anyone had tampered or monkeyed with of those records?
No, sir, and we actually engaged in a stipulation regarding the accuracy and admissibility.
And that would be because both parties knew she was a salaried employee who did not punch a clock. So those records are of limited value. And that is why, knowing full well what the work records showed, we believed that there was an explanation that Mrs. Anthony could give as to why she ran those searches. So it was, we know that this is the good and this is the bad, and we could basically compare the two, and if she can explain, perfect. And that's exactly what she did on the stand. She didn't go any further. She didn't take it any further as far as her direct examination was concerned. And that is when the state decided to go out and elicit more information and then just go ahead and introduce these new records.
Anything else from my adversary? To state, the court will make the following finding of fact. The court will find that this was not a discovery violation. As soon as these particular records became pertinent, the state of Florida sought those records and provided those records to the defense. Trials are supposed to be about a search for the truth. Juries are supposed to be given sufficient evidence so that the jury can take the law, apply it against the facts, and speaks a verdict that renders the truth. The court will instruct this jury certain factors dealing with the credibility or believability of witnesses. As I've indicated earlier, They will be instructed that they can believe or disbelieve all or any part of any witness's testimony. The remaining question is how much time does the defense need to adequately review these records and be prepared to effectively and intelligently cross-examine the witness who will be presenting this testimony. The defense has indicated that they need their, quote, computer to